Authors and artists, creating, expressing the ideas, the feelings that are in all of us. Their talents are as varied as they are, but each share something in common, something that allows them to create and produce freely, something that helps ensure ownership of their life's work. That something is copyright. Copyright is a form of legal protection automatically given to all creators of original works of authorship. Copyright protection is provided for both published and unpublished works and gives the owners or their representatives the exclusive right to reproduce their works in copies or phonorecords, prepare derivative works based upon the original, publish, distribute, publicly perform, or display their works. Copyright protection is equally available for the first-time author or the publishing giant, for the aspiring composer or the established record company. It allows individual creators and companies to own their work and receive compensation for its use. It has not always been this way. Ironically, copyright was once used as a means of censorship by the English Crown to maintain control over everything printed in the realm. It was not until the Statute of Anne in 1710 that an author's legal right to his or her own work was fully recognized. English colonists coming to these shores brought with them the legal precedents for copyright. America's first national copyright law was passed in 1790. Initially, it protected only the authors of books, maps, and charts. But in the ensuing years, Congress added musical compositions, dramas, fine prints, commercial prints, labels, cartoons, photographs, motion pictures, and sound recordings to the growing list of copyrightable materials. By the end of the 19th century, creative materials of all kinds and descriptions were being produced by the thousands. But such growth and proliferation began to strain the laws of a simpler era. And in 1909, President Theodore Roosevelt signed into law a new Copyright Act that would last almost 70 years. Among its many provisions, the 1909 law created a 28-year term of copyright protection with a renewal term of another 28 years. The law also codified and clarified legal protections for nearly all areas of artistic expression. And it reaffirmed the principle that applicants must deposit copies of their registered work to ensure the full benefits of copyright protection. The Library of Congress had been America's sole repository of copyright deposits since 1870. By placing these deposits in their permanent collections, the library soon became one of the world's great research institutions. The person most responsible for this development was Ainsworth Spofford, Copyright Officer of the United States and Librarian of Congress from 1865 to 1897. Spofford envisioned a grand national library built on the foundations of copyright deposits. The problem was where to put it all. Located at that time in the Capitol building, Spofford's office had no room to expand. There were 70,000 books piled everywhere on the floors. Valuable prints and irreplaceable maps had no adequate storage facilities. Cataloging became a losing battle, and only Spofford's remarkable memory prevented many deposits from being hopelessly lost. Finally, in 1886, Congress authorized a new structure to house our national collection. When the Library of Congress building was completed in 1897, the Copyright Office became a separate department of the library. Besides its better storage facilities, the entire Copyright Office was thoroughly equipped and organized by the time the 1909 law came into effect. But the 20th century, remarkable for its rapid technological advances, began opening even newer avenues to creativity and its products. And as the number and diversity of copyright registrations began to double and even triple, it became abundantly clear that copyright would have to once again undergo significant change. Today, the Copyright Office receives more than 500,000 deposits a year. There's a new office in the Library of Congress's James Madison Memorial Building. New procedures for retrieving, tracking, and cataloging deposits. New equipment for the creative products of a modern age. New duties for divisions such as licensing, which administers the complexities of jukebox and cable TV licenses, and a new law. In effect since January 1, 1978, the current copyright law protects a work for the author's lifetime plus an additional 50 years after the author's death. For commissioned works or works made for hire, that is, by businesses or their employees, copyright generally lasts 75 years from the work's publication. Copyright owners whose works were published or registered before 1978 must file renewal applications to gain a second extended term. Registering an original work with the Copyright Office is not generally required to maintain copyright protection under the present law. Once an original work is written down, recorded, or tangibly fixed in an acceptable form, it is in effect copyrighted, and no other action by the Copyright Office is necessary. There are, however, several advantages to registering a copyright claim. Registering establishes a public record of the claim. It's ordinarily necessary before any infringement suits can be filed. And if a work was originally published without notice of copyright, subsequent registration can help establish a claim. Copyright protection is available for literary works, dramatic works including accompanying music, musical works including accompanying words, pantomimes and choreographic works, pictorial, graphic, or sculptural works, motion pictures or other audiovisual presentations, and sound recordings. The United States copyright law protects these and other creative endeavors, but it does not protect titles, names, short phrases or slogans, familiar symbols or designs, mere listings of ingredients or contents, simple variations in lettering, calligraphy, or coloring, works that have not been fixed, such as an improvisational speech or performance that has not been written or recorded, and works like calendars that consist entirely of information that is common property and contains no original authorship. Some creative works not protected by copyright may be subject to protection offered by patent, trademark, or unfair competition laws. Owners of copyrightable material who choose to register their works with the Copyright Office will find the procedure rather simple. They must send in a properly completed application form, a $10 filing fee, and a deposit of the work being registered, 1 copy for unpublished works, 2 for published ones. Some works do not have to be deposited in their original form to secure registration. Proper identifying materials such as a photograph or drawing is all that is required for certain items, particularly three-dimensional ones. To avoid problems with any registration, it is important to send all 3 items to the Copyright Office at the same time and in the same package if possible. These packages should be sent with a check or money order to the Register of Copyrights, Copyright Office, Library of Congress, Washington, D.C., 20559. There is no requirement that applications be prepared or filed by an attorney. It is important, however, for the applicant to fill out the correct form. TX for non-dramatic texts other than periodicals. SE for serials. Serials include newspapers, magazines, journals, and other similar publications. PA for works of the performing arts, such as music, dance, plays, motion pictures, and other audiovisual presentations. VA for works of the visual arts, photographs, graphics, and sculptures, to name a few. SR for sound recordings, and RE for renewals. A copyright registration is effective on the date all 3 items are received in acceptable form at the Copyright Office. The time it takes the office to process an application will vary. The office must check all applications and deposits, call or write registrants if there are problems, and carefully record and log each item. All applicants who meet the legal requirements for registration will receive a certificate of registration once office procedure is completed. It is important for copyright owners to put a notice of copyright on all published works. The notice should be clearly visible and must contain the following elements: the symbol C with a circle around it, or the word copyright, or the abbreviation COPR period, the year of first publication, and the name of the owner of copyright. For sound recording, copyright owners should use the symbol P with a circle around it instead of the C with a circle around it. The copyright law requires 2 deposit copies from all authors who publish a work with a notice of copyright. These and other deposits are then made available to the Library of Congress. Library representatives come to the Copyright Office every day to make selections, and although not everything is selected, all deposits are cataloged and listed in the permanent records of the Copyright Office. These records are open to the public for search and review. Here one can find the works of the famous and not so famous. They bear witness to the magnificent output of the American creative mind. If researchers want information pertaining to the history or ownership of individual registrations, they can search the files themselves, or for an hourly fee, the office will search the files for a requester. It will not, however, investigate the content of a registration or compare it to existing or pending registrations for possible infringements. The entire copyright process contains numerous procedures, concepts, and exceptions that all artists and authors should be acquainted with. Circular R1, Copyright Basics, is a good starting point for understanding the rudiments of copyright protection, registration, and deposit. And there are scores of related publications on nearly every aspect of copyright. There is also a skilled staff of copyright information specialists available to the public for questions and guidance, and with the exception of giving legal advice, they will help with inquiries any way they can. Within the many divisions that make up the United States Copyright Office, there are personnel whose tasks and duties touch every aspect of copyright, including reporting to Congress about any and all developments in the world of copyright. Copyright, after all, is an ever-changing, ever-evolving process. We've come a long way since 1790. The books and maps have been joined by games, toys, textile designs, video discs, even computer programs. Other technologies will be added. New laws will come to pass, but change will not alter the principle of copyright. Copyright is fixed in American law and life. It protects creators of original works of authorship and gives them the freedom and economic incentive to produce more and varied products. In so doing, copyright enriches the cultural output of the nation, and that benefits all of us.